following year, Congress passes the General Allotment Act.
Okay. Here's the thing that I think I was most bewildered by. By 1887, we understand that there are, in fact, some times and places where Indian tribes do own their own land. They're not held in trust. They're held in fee simple. The Cherokees, for instance, buy their reservation. They own it outright, the way that I own my car. But with the General Allotment Act, we're now told that you are no longer going to own your own car or land. How does that happen legally?
Yeah. Well, the Cherokees, the 5 tribes in eastern Oklahoma, were all the tribes removed in the wake of Worcester versus Georgia. And part of the deal that they cut, remember, understanding that Georgia's power to legislate over them, which is the only reason they left, had been based on its ownership of their land. All 5 of those tribes said, here's the deal. We'll remove at least those portions of the tribes that agreed to sign removal treaties. We'll remove, but when we get out to this new land, we're going to own our land.
Period.
Period.
Under your rules, under our rules, under anybody's rules.
Yeah, so it isn't so much that the Cherokees bought their land, it's that was the removal deal that they struck in order to avoid getting into the same situation out here with some future state government that they had run into with Georgia, right, where the state would claim based on ownership the power to exercise jurisdiction over tribes. So that's those tribes. Now, the reason that what happened in the General Allotment Act didn't say, everybody's allotted. What it did was to empower the executive branch of the federal government to send agents out to meet with tribes, to negotiate deals under which the tribes would essentially agree to the division of their lands into individual fee parcels. They wouldn't be Cherokee, they'd be fee. There's 5 tribes, but they'd be trust, what we call trust lands, because the U.S. would still own the underlying title elsewhere. And then surplus land, so it'd be a per capita distribution. Everybody gets the same amount of acres, and anything left over would be either purchased by the United States or sold for the tribe's benefit by the United States. The reason that they could do this to tribes that own their lands, etc., was that they were acting as guardian in the tribe's best interest.
In the tribe's best interest.
Yeah, and it didn't matter. It will turn out in a 1903 decision called Lone Wolf versus Hitchcock, if the tribes had treaties that said, you can't do this. Congress still could step in and authorize the executive to do this because it's the guardian for the tribes.
Okay, and Lone Wolf challenges that notion.
Lone Wolf was a fight over the sort of technicalities of the allotment deal supposedly struck between the United States and the Kiowas, the Comanches, and the Fort Sill Apaches in western Oklahoma. And those tribes had reached sort of agreement on how big the individual parcels would be and who was going to get them, and that the surplus lands would be purchased by the United States. But they had failed to reach agreement with the U.S. on how much the tribes were going to get for the surplus lands. The U.S. made an offer, the tribes said, oh, we need a lot more than that, and they never reached agreement when they were negotiating. So what the U.S. negotiator said at the end was, well, why don't we just leave it up to Congress? And the tribes said, well, that's okay. But then they put a line in the statute that they then sent to Congress to memorialize this deal that said, and the price paid for the surplus lands will be our figure. And if they don't like it, they can complain to Congress, which isn't exactly the same thing, right, as leaving it open and up to Congress.
Right.
So that went through, Congress passed as a statute, and they started to allot, and the tribe said, what? This isn't what we agreed to. Now, they had a legal out, they thought, because the treaty that these tribes had with the U.S. that was decades older than the Treaty of Medicine Lodge, older than the allotment deal, included a provision which was common in a lot of Western treaties with tribes that said that no future land cession will be valid without the consent of 3/4 of the adult male tribal members. The U.S. had tried to get consent from 3/4 of the adult male tribal members of these tribes, and they thought they had. But when Lone Wolf went to Washington to protest the dollar figure for the surplus lands that went into final statute, he went over, took a look at the list, and realized that they didn't have enough people. that they didn't get enough signatures, which meant that the deal that had been legislated in the allotment statute for these
didn't
three
satisfy the treaty.
was invalid
Right.
under the treaty because
Right.
it was a breach of the treaty obligation. Lone Wolf versus Hitchcock then was Lone Wolf's federal lawsuit on behalf of these three tribes against the Secretary of the Interior to invalidate the statute that had allotted them.
Right.
What they were mad about was the amount for the surplus lands, but their legal basis was it violated the treaty. And the Supreme Court looked at it and said, it does violate the treaty,
But
it doesn't matter. And it doesn't matter because Congress is the guardian, and as such, Congress has, and the term that they used was plenary power over Indian affairs.
this is a troublesome one for us.
Well, we don't know what it entirely means, plenary. That, and this is sort of a funny thing that it still gets discussed in the academic literature. Plenary could mean
Absolute.
complete and absolute, meaning they get to do anything they want to do.
Right.
But it doesn't play out that way.
Right.
It may mean unlimited as to subject area, so comprehensive, right? So it can be criminal law, it can be other stuff as the guardian, and that's more sort of consistent with our understanding of, of Kagama and what all that meant.
And maybe even with the actualities.
Right. Well, and the way that
the way cases get
that the
decided.
power has been employed. What Lone Wolf says in the Supreme Court, the Lone Wolf, the person, in the wake of this determination that congressional power is plenary, and that the plenary power of Congress as guardian at least includes the power to override or abrogate, is the term that we use, sort of treaty provisions that are uncomfortable.
Right.
Lone Wolf says, okay, well, if they're acting as guardian, then as guardian, they've got an obligation to act in good faith, right, in our best interest, and this isn't in our best interest. And what the Supreme Court says to that argument in this 1903 decision, Lone Wolf versus Hitchcock, is, well, you may be right. Yeah, I guess they have that obligation, and you may be right that they violated it here. But that's what we call a non-justiciable question.
This is not a case for the court to decide.
Meaning it's not a case for the court to decide.
Okay.
We don't have the jurisdiction to decide that question, the question of whether Congress has violated its good faith obligation. The party to go to make that objection is Congress, right? So go tell the guardian you think that the guardian has violated his obligation. If the guardian agrees, then they can repeal the statute, basically.
That seems a little unlikely.
Yeah, and kind of unfair. And unfortunate, certainly for tribes. Now, it's Lone Wolf that opens the door to wholesale abrogation of Indian treaties. And I think that's important to understand too. We think of the whole era as, Congress is always violating treaties. Not entirely true. And as we saw in the Lone Wolf case, Congress actually tried to get these signatures prior to 1903. But after 1903, there's no consequence to not getting them. So other than, political consequence, but there's no legal consequence to not getting them.
Right.
So that opens the door to wholesale abrogation of Indian treaties in the interest of allotment, which is still proceeding after 1903. I should say that rule's changed. There is still, the Supreme Court has found there is a good faith obligation that attaches to Congress when it acts as guardian, and it's justiciable, the question of whether they violated that obligation.
Right.
And so tribes do bring cases now for breach of good faith, and they can ask for cash, and they can also ask for injunctive relief to get a court order that the Congress or the executive go back and do it again, right, in our best interest.
And so this gets us, for instance, to the Cobell settlement.
Right.
Is that right? Okay. What made for the change?
Changes in I think, attitudes towards federal Indian policy.
Okay.
In 1903, we're in what we broadly call the allotment era or the assimilation era, where it's the expectation of most folks in the federal government that tribes are on their way out, that they're all going to be assimilated, tribal governments will be abolished. So these are all just steps in that process. But the case that sort of fixes the justiciability of the question of breach of good faith by the federal government is a case from 1978 called Delaware Tribal Business Committee versus Weeks. 1970s, we're into radically different period.
Right. By that time, the IRA, the Indian Reorganization Act, has come around.
Yeah,
the Indian Citizenship Act has happened.
Well, all of those things, but even more recent than that, 1975. is the legislative inauguration of what we call the self-determination era.
Right.
And that's the era in which we currently find ourselves. Since the late 60s, early 70s, it's been Congress's position that tribes are here to stay. The tribes have protected rights of self-governance that in some ways turn out to be fairly expansive under federal law. And these rights include the right to go after the federal government. If Congress has acted as guardian or the executive has assumed Congress's role as guardian and violated the good faith obligation.
Well, it sounds like we're on the upswing, but not without some contemporary challenges. Maybe we could talk about those the next go-round.
Sure.
Great.